I'm David Lillehaug. I'm a retired justice in the Minnesota Supreme Court, and now at JAMS I'm providing neutral services, including arbitration, mediation, special master work. I approach mediation first from the standpoint of respect. The parties are there to try to get something done. They've honored me by involving me in their case. Now, of course, neither of them is my client. My client is the potential agreement that's out there. And they're relying on me to have persistence and creativity and ideas. So having that basis of trust with both parties is indispensable to me being the representative of the deal. Mediation is effective because it's consensual. By the time you get into a courtroom, a jury room, there's a lot of time, money, and emotion under the bridge. And what is also under the bridge is time of the people who are involved in the process. I tell almost every general counsel that I work with, you're not valuing your own time adequately. If you're not going to settle in the mediation and you're going to have to devote an enormous amount of time to the case, that is time that you're not putting into the business. That is not time that you're advising the CEO to keep the company out of trouble. Value your time properly. The thing the parties can best do to help arbitration move more smoothly is to understand this is arbitration. This is not litigation in a courtroom. And so if the arbitration boils down to a bunch of one-sentence pieces of testimony, followed by an objection, followed by an argument, followed by a ruling, we're not going to get very far. The arbitration is not going to be what the client's contracted for, to have speedy, just adjudication. We may eventually get the just, but there needs to be efficiency as well. That's what the parties have contracted for. The area that interests me most, and this is a broad area, but it's complex litigation. I cut my teeth growing up as a litigator on big cases, and everybody's brought into a case like that. And you've got the counterclaims, you've got the cross claims, you've got the claims for indemnification. You've got different layers of insurance stacked on one another. I love that kind of work. It's intellectually challenging, and to be able to help the parties, whether by mediation or arbitration, navigate their way through that thicket of claims is something that really gratifies me. Litigation can be a blood sport. It can be an ugly process. It can be long and taxing, and in some ways degrading. So getting to a yes early is extremely gratifying to me because it tells me the parties have not invested months, maybe years, in an enterprise that's about the past, but instead are investing their time and effort and resources and emotional energy in the future of business.